Yeah, my name is John Curtis. I'm with the firm Rocky Mountain Advisory, LLC, and I've been practicing for about 20 years. Started out my career with the accounting firm PricewaterhouseCoopers, a national firm, and I was there for about 11 years. And then we formed our current firm just over 11 years ago. So I've been with them ever since. And practice focuses in areas of bankruptcy, restructuring, turnaround, and we do a lot of fraud investigations and investigative accounting work as well.
And are you able to talk about any of the past cases that you've been involved in?
Yeah, sure. Yeah, I've been involved in some of them are public, so I could probably mention a few names. But one of the larger cases it's a case out of Idaho called DBSI, and the trustee was actually out of New Jersey, Jim Zazzali, who's was a former judge. And because of our proximity, I think, to Idaho, we got involved, and that was an interesting case. It was a massive real estate development case involving investors, but also allegations of Ponzi scheme, and there were a lot of clawback actions, so very complicated. There were, fraudulent transfer claims, and so we had a number of roles in that case. We were insolvency experts. We testified as to the Ponzi scheme and characteristics of the Ponzi scheme, and also some specific issues on some of the cases where transfers made to folks and what sort of value they received or gave in consideration for the transfers. And that was a fun case. Yeah, a number of cases here locally as well. I've been in a couple of cases in New York City also, and around the country. But yeah, all sorts of industries, been involved, from construction to energy companies to real estate development companies, crane services company, and both Chapter 7 and Chapter 11 cases. We do a fair amount of work here for some of the Chapter 7 trustees, so those are a lot of clawback cases, I guess.
In the context of have you ever worked on preference cases before?
I have.
Any involvement in that?
I have, quite a bit, yeah.
And how would a preference defendant use an expert like yourself?
Yes, we've been hired by preference defendants usually on issues of proving their defenses. So one of the defenses would be whether the transfers were made in a way that's ordinary between either the two parties, the creditor and the debtor. So we'll look at a history of payments between those parties. If we can show they were ordinary or kind of within the normal realm of how their history, that's a good defense. Another one is ordinary in the industry. And so we'll present industry data and that the payments were not outside the reasonable ordinary terms between parties in the industry. We'll also show that whether the creditor provided new value or essentially continued to extend credit or goods or services to this debtor after the alleged preference payments were made. So we can help provide that. We'll also sometimes rebut the insolvency assumption. So we'll look at whether the debtor was solvent when these payments were made, which is sometimes the case where there can be an argument for it. So those are probably the main defenses. We probably more have been involved on, I guess, the plaintiff side of preference cases, but that helps us on the defense side too to understand what the defenses are.
In fraudulent conveyance cases, how would you get involved as an expert?
Usually in fraudulent conveyance, it's a couple or two or three issues. Solvency is a big one because typically they go back past the 90 days into, up to 4 years in some cases, as to whether and when the debtor became insolvent or whether the debtor was solvent. And what that means is whether it's the value of its assets exceeded the value of its liabilities at a fair valuation typically, or some premise of value. So insolvency, there's also the issue of value in the legal sense. I think it's reasonably equivalent value. That's more of a legal issue, but we'll get into what value was given or consideration exchanged for the transfers. Those are the main things. Sometimes actual fraud is an issue. So we'll look at evidence of intent or defenses to the fraud that if there's financial information that can support or rebut issues of fraud, allegations of fraud, I guess. We'll look at, so if the debtor made payments to an entity in exchange for real estate, for example, we're not appraisers, but often there may have been appraisals that existed at the time, or brokers' opinions of value, or there may have been, or even tax records or tax valuations or different things like that, or it could be goods and services that we can show the debtor provided certain things in exchange for the payments, or if there's sometimes ways to value it, and contemporaneous information we can look at. Yeah, sometimes gathering sufficient data is difficult. It depends on the case, but sometimes the records have not been maintained as the way we'd like. It depends on the case. Chapter 7 is especially interesting. Sometimes you just can't find the records, or there's that. There's sometimes there's just getting cooperation is challenging. I mean, in any case, that can be a challenge. I don't know. Overall, I feel like bankruptcy is a pretty good realm to work in. There's a fair amount of transparency, and you've got a judge involved. Sometimes there's a trustee or U.S. trustee's office involved as well, and it feels like it's fairly streamlined to get information needed. So I'd say for the most part, we issue a report. Often, in my experience, cases settle, but I mean, we still testify in court, and it's probably, several times. I do several times a year. Sometimes there's a deposition, and then it doesn't make it to trial because it settles. But I'd say more reports than testimony. But then again, there's also, I've done a fair amount of testifying in hearings before a trial or something, just a hearing on a valuation issue, or a hearing on a preliminary issue, motion for summary judgment, for example, or something like that. So, so there's some, not necessarily trial, but hearings as well. Anywhere across the country. I did a case in Houston for the last couple of years, but that was actually flying to Houston. I was testifying in court there, Judge Isker. It was a kind of a case involving attorneys around the country, and so I've been there. I've been to New York, but mostly here. But I guess now with a lot of what we've learned through COVID-19, I think we've learned that we can do a lot more remotely, and we've even heard from our bankruptcy judges here locally that they may continue to do a lot of their hearings via technology, just so people don't have to spend so much time traveling and things like that. So I think it opens a lot of doors. Yeah. So I think the way we were found out from another New York firm is we had a case in New York City that involved fraudulent transfer related to an entity in Utah, and the issue was the debtor was claiming that no value had been given by this Utah company in exchange for the transfers. The defense of our attorneys was that the subsidiary and the parent were essentially alter egos of each other. It was one unified enterprise, and as we did our analysis from a financial perspective, it was plenty of evidence to support that. It was the entities basically operated as one. I mean, there was confusion about corporate identity. We looked at it from a financial perspective and showing how the payments and the money flowed. And in fact, all of the subsidiaries' money was swept up to the parent. So, I mean, it wasn't even able to control its own money. So it was a fairly simple case to make, but I think it really hurt the plaintiff's case, just because there was just so much evidence that they operated as one entity. So the value, I think it blew out of the water their value claim.
I'm going to interject. John is being a little bit modest here. I think he won that case for the plaintiff with his expert analysis and testimony.